This is English shorthand dictation number 366 and the dictation speed is 120 words per minute. Ready? Start. The workman is, before this court, impugning the order passed by the division bench of the High Court in an intra court appeal, whereby the order passed by the learned single judge in the writ petition was upheld. The learned single judge of the High Court had set aside the award of the tribunal. Void the aforesaid award, the prayer of the workman was accepted, and order dated 05/12/1984, deeming that the workman had voluntarily retired, was set aside. He was directed to be reinstated with full back wages along with interest and consequential benefits. The brief facts of the case, as are available on record, are that the workman was appointed with the bank on 20/06/1977 as clerk cum cashier. Initially, he was working at Barabanki. Thereafter, he was transferred to Sitapur and then to Hardoi in August 1978. On 14/06/1982, he was suspended on account of his disorderly behavior. On enquiry, the workman was found guilty of the charges and awarded punishment of stoppage of two graded increments with cumulative effect. Wide order dated 28/09/1983. Via the same order, he was advised to report for duty to the manager branch office Unnao. The workman failed to join duty. As per the terms of bipartite agreement between Indian Banks Association and workmen unions, wide order dated 05/12/1984, the workman was deemed to have voluntarily retired from service. Aggrieved by the aforesaid action of the bank, 6 years later, the workman raised a dispute about his deemed retirement before the Assistant Labor Commissioner. On 15/11/1991, the dispute was referred to the tribunal for adjudication. The question referred was answered by the tribunal in favor of the workman. However, the learned single judge reversed the award of the tribunal and the division bench upheld the order passed by the learned single judge. The workman, even as per the material available on record, has joined active practice as a lawyer after his deemed voluntary retirement from service with the bank, has appeared in person and argued before this court. Even the tribunal had recorded that the workman had appeared himself in person and had addressed arguments. The workman who appeared in person submitted that the disciplinary authority, while passing the order of punishment after enquiry, could not have ordered his transfer in the same order as the competence to order transfer of the workman lied with a different authority. The workman had been raising that issue before the authority. However, the same was not addressed, and in an illegal manner, he was deemed to have voluntarily retired. He was not given joining time also. He made a number of representations to revoke his suspension to enable him to join the place of posting after his reinstatement. He had even gone on hunger strike, but none of the authorities redressed his grievance. He was not even paid subsistence allowance for the period he was under suspension. After passing of the punishment order in the enquiry initiated against him, he could not be continued on suspension as the order dated 28/09/1983 stated that he shall be deemed to be reinstated only on joining at the new place of posting. He sought to explain his reasons for not complying with the order of transfer by explaining that the branch office Unnao was at a distance of 350 kilometers. There was non payment of allowances, including subsistence allowance, for the previous period, and if he was stated to be under suspension, he could not have been transferred as the transfer was possible only after his reinstatement. On the other hand, learned counsel for the bank submitted that seeing the conduct of the workman who had been misbehaving with his senior officers and was also in the habit of not complying with the orders of the authorities, he was imposed a very light punishment of stoppage of two graded increments. Otherwise, the notice issued to him after enquiry was to show cause as to why he should not be dismissed from service. There is no place for any indisciplined person in any institution, especially in a bank where entire business depends upon the dealing of the staff with its customers. Even after the punishment was imposed upon him, and to avoid any further untoward incident, seeing his past conduct, the workman was directed to report for duty at a different branch. However, the workman did not comply with that order and continued raising the dispute with the bank at different levels. He further misconducted himself by sitting on a hunger strike. This aggravated the issue and shows the attitude of the workman who was not fit to be retained in service. It was contended that there is no error in the orders passed by the High Court setting aside the award of the tribunal, and the workman does not deserve any relief. We have heard the workman who appeared in person, the learned counsel for the bank, and perused the relevant record, a fact which is not in dispute and has been specifically recorded by the learned single judge of the High Court in his order is that in the year 1985 the workman got himself enrolled as an advocate with the Bar Council of Uttar Pradesh. It was admitted by him that he had been handling cases of the union and other employees of the bank. It is a fact that the workman was awarded the punishment of stoppage of two graded increments wide order dated 28/09/1983. In the same order, the workman was directed to report for duty to the manager branch office Unnao. The fact which remains undisputed is that the workman never challenged the order of punishment or his transfer before the competent authority or the court, and the said order became final. He was only aggrieved with his posting to the branch office Unnao. Instead of joining his new place of posting, he continued writing letters. As per the terms of the bipartite agreement, in case a workman remains absent from work consecutively for 90 days or more without submitting any application for leave, the bank is entitled, after 30 days' notice, to conclude that the employee has no intention to join duty and is deemed to have voluntarily retired on expiry of the notice period of 30 days.